Hello, I'm attorney Paul Whalen with Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts, oftentimes at a reduced rate, making ourselves more affordable to our clients. On today's episode, I just want to take a moment to discuss dangerousness hearings in Massachusetts. What is a dangerousness hearing? Well, what happens is when you're charged with a crime, you go for an arraignment. That's the first step in the process. That's where the court tells you officially what the charges are against you. And oftentimes the court will either release you on personal recognizance, that just means you get to leave without having to post any money, or they'll set a cash bail for you, which means that you have to put up that much money in order to get released. However, if you are charged with certain offenses, and those offenses are generally crimes of violence, serious felony charges, and OUI charges, so operating under the influence charges, if it's a third or subsequent offense, you can be held as a danger. So what happens is at the time of arraignment, the Commonwealth, that is the prosecution, will make a motion to the judge asking that you be held in custody, so that means in jail, pending the outcome of this dangerousness hearing. So the first step is at the arraignment, and the judge just has to be shown two things. Those two things are, one, that one of the charges, at least that you're being charged with, falls under this dangerousness statute, and number two, that there is probable cause to believe that you committed that crime. So it's easy enough to the judge can just easily look to see what the charges are against you, so they know yes or no you fit into that category. The second phase of that, the second prong, is that they have to prove that there was probable cause to believe that you committed that crime. Probable cause is a very low standard for the Commonwealth to have to prove. It's very easy for them to make. So in all likelihood, if they're asking that you be held as a danger, you probably will be held as a danger in custody. So what happens is that's the first step of the process. Then you'll have a full dangerousness hearing that will be scheduled, and that dangerousness hearing would be scheduled typically from 3 to 7 days from the date of arraignment. So you'll be held in jail for that period of time. It can go longer, it can be shorter, but typically 3 to 7 days is what's required under the statute, unless there's good cause to continue it. So you come back on that date for a dangerousness hearing. And at that point, the Commonwealth has to put on evidence about the case, about your charges, again, about the probable cause that you committed those charges. And they have to prove that there are no less restrictive means to provide for the safety of the public, less restrictive than keeping you in jail. So the court doesn't want to keep you in jail if it doesn't have to. So they're looking to see if there are any other alternatives. So at the hearing, the Commonwealth will proceed with evidence. They can bring in witnesses. They can present evidence, documentary evidence, or photographs, things of that nature. They would present your criminal record if there is any. They would present the police report to the judge. Sometimes the Commonwealth goes what they call off the papers. That just means that they won't call any live witnesses. They're just going to submit the police report and perhaps some other documentary evidence, such as photographs. You have the ability, your attorney, working with your attorney, to call witnesses to make your argument why you are not a danger. You can call witnesses about the facts of the case. You can call witnesses about your situation and why you would not be a danger to the community. So the judge at that point during that hearing has to make a determination. Once again, it's a two-pronged determination. First, are you a danger to the community? Are you a dangerous person? The judge can say, if the judge says no, they do not find you as a danger, as a dangerous person, then they will not hold you under the dangerousness statute. They will release you. Perhaps they would put cash bail on you. That's a different story. But if you're found not to be a danger, they won't hold you as a danger under that statute. The next step is, if they do find that you are a danger to the community or one particular person in the community, they next have to decide, are there any less restrictive means that we can impose upon this person rather than taking away their freedom and holding them in jail? Most commonly, those other conditions are home confinement, to put you on a GPS so that the ankle bracelet so they know where you are, to stay away from certain people, certain locations, to take part in substance abuse treatments, to remain alcohol or drug free with random screens, to have a curfew. There can be a whole number of conditions that a judge could impose rather than holding you as a danger. So it's oftentimes on the second prong is when we're able to convince the judge that even if they do think that you're a danger, that you should still be released and still have your freedom while your case is pending. If the judge decides that you are a danger and there are no less restrictive means rather than holding you in custody, they can hold you for up to 120 days without the chance of being bailed out. 120 days. So that's basically 4 months that you could be held in jail without ever having another hearing, certainly without a trial. It's really, I understand what the thought behind it as far as protecting the community. Obviously, an incredibly important goal for the justice system. However, we do have a innocent until proven guilty theory in our criminal justice system, or at least we're supposed to. So to hold you without making the Commonwealth put on their full evidence and convince a judge or someone to beyond a reasonable doubt standard seems to me unfair. But again, as I've said before, my opinion doesn't matter in most anything. You can ask my kids. But in this case, that's what you're facing. That's what you're looking at if you are facing those specific charges. So at Afford Law, we do criminal and family law, and we practice our practice is all surrounded by us trying to make ourselves affordable to the working man and woman in Massachusetts. For far too long, that group of people who go out every day, earn their living, make their way in life, support themselves and their family, are confronted with a family or a criminal law situation, and they cannot go out and hire an attorney, or they can't do it without imposing great financial restrictions on themselves and a financial burden. So what we do is we use a sliding scale fee. The sliding scale that we use is based on your income. So the less you make, the less we charge for our services, so that we can make ourselves more affordable, because we feel and we know that it's incredibly important that you be represented in family law and in criminal law matters in Massachusetts. The issues are very complex, and the consequences of those issues are immense. In this case, when we're talking about criminal law and specifically on dangerousness hearings, you could lose your liberty, you could lose your freedom, and you need to have an advocate in your corner working for you who knows the law, knows the process, and can put on the absolute best defense for you. So if you have any questions, we'd certainly be happy to answer your questions, address any issues that you might have. Please feel free to visit us at affordlaw.org. That's not .com, so it's affordlaw.org. Check out our frequently asked questions. We have a lot of videos and a lot of resources for you there. If you have any questions, please feel free to give us a call, and we'd love it if you would like to book a virtual initial consultation. It's absolutely free. There's no obligation whatsoever. You can get some good information to decide where you stand and what your next step should be. At Afford Law, we're making justice affordable. Thank you.